attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the SEC's Division of Corporation Finance, known as CorpFin's disclosure review and comment process. Although the basic process involves letters and responses, the CorpFin staff is available to discuss comments with a company and its legal, accounting, and other advisors. The process can and often does involve these informal conversations. CorpFin will not give legal or accounting advice, but it will talk through comments and responses and discuss the analysis and adequacy related to the disclosures. The initial comment letter received from CorpFin will have the reviewer's direct contact information. The back and forth process does not require a formal protocol other than the required written response letter. That is, a company or its advisors may engage in conversations regarding comments or request that the staff reconsider certain comments prior to putting pen to paper. CorpFin encourages this type of conversation and discussion, especially where the company or its advisors do not understand a particular comment. The staff would rather discuss it than have the company guess and proceed in the wrong direction. Where the staff suggests that a company should revise its disclosure or its financial statements, the company may and should, as appropriate, provide the staff with a written explanation of why it provided the disclosure it did. This explanation may resolve the comment without the need for the requested amendment. A CorpFin review is not an attack and should not be approached as such. My experience with CorpFin has always been pleasant and involves a type of collaboration to improve company disclosures. A company may also go up the ladder, so to speak, in its discussions with the CorpFin review staff. Such further discussions are not discouraged or seen as an adversarial attack in any way. For instance, if the company does not understand or agree with a comment, it may first talk to the reviewer. If that does not resolve the question, they may then ask to talk with a particular person who prepared the comment or directly with the legal branch chief or accounting branch chief identified in the letter. A company may even then proceed to speak directly with the assistant director, deputy director, or even the director. Matters of legal disclosure or application of GAAP accounting principles are not an exact science, and the discussions are encouraged such that the end result is an enhanced disclosure by the company and consistent disclosures across different companies. The SEC provides all of these individuals' contact information on its website and will willingly engage in productive conversations with a company. When responding to comment letters and communicating with SEC staff, it is important that a person who understands the process, such as SEC counsel, take the lead in communication. Responses should be consistent, both related to a particular comment and over time. A company that flip-flops on accounting treatment or disclosures will lose credibility with the SEC and invoke further review and comments. CorpFin is also willing to provide a reasonable amount of extra time to respond to comment letters when requested and reasonably necessary. Most comment letters request a response within 10 days. CorpFin is usually willing to give an extra 10 days, but will balk at much longer than that without a very good reason by the company for the delay. If the reviewed filing is a Securities Act registration statement, such as an S-1, the CorpFin staff will verbally inform the company that it has cleared comments, when it has cleared comments, and that the company may then request that the SEC declare the registration statement effective. When the reviewed filing is an Exchange Act filing that does not need to be declared effective, CorpFin will provide the company with a letter stating that it has resolved all of its comments. I'm attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.